for providing me the opportunity to speak today. And the various sessions has been organized by the ICSI IPA. So thank you so much for giving me the opportunity to speak before all the participants and take their overviews on all the regulations. So, this is the last webinar of this series. So, without any delay, I just start because today's regulations is having 80 pages. So, we'll share the regulation first. And welcome to all the participants who are continuously is joining from the beginning of the sessions. So I'm very thankful to all of them. So because they have take the initiatives and they have also provided their all views for the further amendments. So I will be thankful to the all the participants also. So just sharing my PPT, my screen. Sorry. Uh, am I audible now?
Yes, ma'am.
Okay, thank you, sir. Thank you. So I just shared my screen. So because this is the today's regulation, because we have already discussed the personal guarantor regulations in the last session. So I don't think there is any other regulations have been left for the discussion. So we'll start with this regulation. The Insolvency and Bankruptcy Board of India Liquidation Process Regulation 2016. So, is my screen is visible now? My
Yes.
screen, okay, okay. Thank you so
Yes.
much. Thank you. So, because this is amended up to 29th January 2025. So, this is also recently amended, which I'm sharing. So, these regulations may be called the Insolvency and Bankruptcy Board of India Liquidation Process Regulation 2016. And the regulation came into force on the date of their publication in the official gazette. And this regulation shall apply to the liquidation process under Chapter 3, Part 2 of the Insolvency and Bankruptcy Code. So basically, this is applicable for the corporate debtors liquidations process, basically defined is here. So in this regulation, unless the context otherwise required, what is the definition? Because second part is the regulation number 2 part is the definition part basically. So, what is the definition is provided here for the books of the corporate debtors. So, basically, this means the books of accounts and the financial statement as defined in section 213 and 240 of the Companies Act. So, whatever is defined as per the Companies Act, so they have taken the same view will be counted as the books of accounts. And the books of accounts as referred to in section 34 of the LLP, if there is the LLP, then the LLP, as per section 34, whatever is provided as per LLP Act will be considered as the books of accounts. Now they have or, because or is here, so they have said ki the books of account as specified under the applicable law. So whether this or this, so any of them can be considered as the books of accounts. So basically this is the definition of the books of accounts which is mentioned as per the liquidation regulations. Now code we know the Insolvency and Bankruptcy Code 2016 and consultation committee, because there is the word is the consultation committee. Earlier we have seen the COC, the creditor committee of creditors, but here they have defined the mentioned the consultation committee. So what is the meaning of this? The means a stakeholders consultation committee constituted under sub regulation 1 of regulation 31A. So the later on we will discuss who will be the part of this committee. So as per the regulation 31A, this is described in a wider meaning. So the here is in the definition they have only mentioned the consultation committee means the stakeholders consultation committee constituted under sub regulation 1 of regulation 31A. Now the contributory, because we all are professionals, so we all have the knowledge ki who are the contributory at the time of liquidation, if company have gone in the liquidation or the LLP go for the liquidation. So contributory means a member of a company, basically shareholder, a partner of the limited liability partnership, and any other person liable to contribute towards the assets of the corporate debtor in the event of the liquidation. So whoever is liable to contribute towards the assets will be counted as the contributory in case of the liquidation. And the corporate liquidation account means the corporate liquidation account operated and maintained by the board under Regulation 46. So whatever the account which is operated by the IBBI will be called as the corporate liquidation account. Now, electronic means we have already read this definition in the earlier regulations also. Means an authorized and secured computer program which is capable of producing, confirming, of sending the communication to the participant entitled to receive such communication at the last electronic mail address provided by such participant, and keeping records of such communication will be called the electronic mails. Now, identification number is we have already discussed this in the earlier regulations also. So for the company case, this is the SIN number, or for the LLP, this is the LLP number. And the liquidation cost under this regulation means, so here they have also defined what is the meaning of the liquidation cost. So fee payable to the liquidator under regulation 4 will be considered the liquidation cost. Remuneration payable by the liquidator under sub-regulation 1 of regulation 7 will be considered as the liquidation cost. Cost incurred by the liquidator under sub-regulation. So these regulations we will also discuss 7, 1, 24, 1, 2. So we'll discuss later on in this regulation part also. And cost incurred by the regulator for preserving and protecting the assets, properties, effects, and actionable claim, including secured assets of the corporate debtor, and cost incurred by the liquidator in carrying on the business of the corporate debtor as a going concern, interest on the interim finance for a period of 12 months, because here they have counted only the interest which is for a period of 12 months, or for a period from the liquidation commencement date till the repayment of interim finance, whichever is lower. So now whatever the cost is lower will be considered at the liquidation cost. How we will count this is we'll take the interest on interim finance for the period of 12 months, or first we will see how much cost for the 12 months, and then we will see for the period from the liquidation commencement date till repayment of interim finance, how much is the cost. So whichever is lower will be considered as a liquidation cost. Now the amount repayable under sub-regulation of regulation 2A, and any other cost incurred by the liquidator which is essential for completing the liquidation process will be considered as a liquidation cost. And provided that the cost, if any, incurred by the liquidator in relation to compromise or arrangement under section 230 of the Companies Act, if any, shall not form part of the liquidation cost. So it is clear here, if the company will go for the compromise or arrangements as per section 230 of the Companies Act, like amalgamation, merger or something, then this cost shall not become the part of the liquidation cost. And preliminary report they have also defined
Madam,
here.
there will be, excuse me, there will be cases which are extending beyond 180 days also.
Sir, this in the liquidation cases, 365 days are allotted. The maximum
Yeah,
period of 1
maximum
year
period
is
is
given.
180 days, but there
Yes.
will be extensions with the approval of NCLT. There are chances for extension also, no?
Yes, sir, go to CIRP. This you are discussion about,
Yeah,
you are
liquidation
saying
also,
about the, yeah,
is it
in
not possible?
liquidation, yeah, in liquidation, this is also permitted, but in liquidation, the period is allowed for 1 year. The 365 days is allotted for completing the liquidation process. Not 180 days, sir.
Sorry, 12 months.
Yeah,
Yeah.
yeah, 12 months. 12
For
months is,
example,
yeah,
the
yeah,
liquidation is, continuing beyond 12 months.
yes.
Then what is the position of interest?
Because
It will not be
here,
paid beyond 12
yes,
months. It will not
yes.
be considered.
Because here they have mentioned only, sir, or for the period from the liquidation commencement date. Suppose if the period commence from the liquidation
Yeah, I got
date,
it.
yeah, till
It's
the,
actually 12 months from LCD.
yes,
If it is beyond 12 months, interest for the a period crossing 12 months will not be considered under liquidation cost.
yes, yes. So they have mentioned here clearly.
Then, then the
So,
financier will be at loss, no?
sir, you can provide your suggestions
Yeah,
because this is a chance.
yeah. That is why
Yeah,
I
yeah,
mean,
yeah.
what I want to say is that
Yes,
as long
yes.
as the interim finance is not paid, I think the financier should get. Otherwise, financier will not come forward, no?
Yes, sir. Yes, sir. You are right on
What
this
other
point.
people?
However, the IBBI intention for this is that the
It should be
liquidation should be
completed.
completed. Yeah, should be
Yeah.
completed within 12 months. Otherwise, if they will exceed the period and something, then some other type of arrangements will be happen now. So they have mentioned here the 12 months. Now you have the chance, you can make your suggestions.
Hmm.
Yeah.
Whichever is, it is better to be whichever is later,
Whichever is later,
lower, whichever is
whichever is lower here, they have mentioned. But
amount. They are saying in terms of amount.
yes, yes. So,
Hmm.
we have to they have to written here whichever is later, not lower, whichever
Hmm.
is later.
Ah.
Okay.
Interest on interim finance for a period of 12 months or for the period from liquidation committed till repayment of interim
Interim
finance.
finance,
If
whichever
it
is
is,
later.
if the liquidation is continuing beyond 12 months.
Yes, so whichever is later will be counted as the interest on liquidation cost of interim finance, interest on interim finance. Any other participants want to say anything on this point? Okay, sir.
Whichever is,
Whichever is later and delete the word lower.
But in this case, I think 1 year will be paid if they get earlier, then at least 1 year interest will be paid.
1 year interest.
Yes.
Suppose if the liquidation is continuing beyond 12 months, that period, for that period,
But
I think financial should be given.
So
Which should also, madam,
the
whichever is lower they have written, it is in the sense of amount, and we are talking in the terms of period. So it should
so
be
period.
whichever is lower is correct, but what you want to add here?
liquidation till repayment of the interest, whichever is maybe higher, I think.
Whichever is
Higher
hmm,
when the liquidation is, continuing beyond 12 months.
Whichever is later.
hmm.
Whichever is later.
Later is period, sir. Lower and higher is amount. They are saying lower. In the original say it is whichever is lower means the lowest of the amounts of the two.
Sir, why not remove the debate about period, interest on interim finance? Finished. That is simple.
So, what your
Irrespective
suggestion,
of
sir?
period.
Yes, yes, sir. Sir, yes, sir.
Irrespective
Whatever
of
period,
period.
whether higher or lower, interim interest should be paid.
Will serve both the purpose, higher for amount also and for
Yes.
period also.
For the
Irrespective.
period for
Yes.
which interim finance is extended.
Whatever is higher and have to add something here also.
No, what he is saying
If-
is that
Yes.
interest on interim finance. That is enough, he is saying.
Yes. Then no need
Yes.
to write whichever is lower or higher.
And it is not required to
Yes.
mention all these things. So interest on interim finance as long as the finance is extended to the corporate debtor.
So whichever is higher is the correct word here.
Whichever is
Then-
lower should be deleted.
No,
Whichever
Yes.
is lower should
Madam,
be deleted.
Yes.
neither lower is required, not higher is required. Only interest on interim finance is required.
Sir, this is already mentioned, interest on interim finance for a period of
And then
12
that
months.
period is
They
not
have-
required to be mentioned. That is what he is saying, madam.
Okay,
Interest
so
on
The-
interim finance for the period available.
for the
Yes.
period of for the period
As long as the
it started,
liquidation-
yeah, it started from the liquidation till the
Till
repayment of interim finance.
repayment.
So
Till-
12
it.
months, yeah, so 12 months there is no need to mention the 12 months or something
interest on interim
Yes.
finance.
for a
Interest on interim finance.
for the period from the liquidation commencement date till the till repayment of interim finance.
Till the closure of liquidation or till the closure
No,
of
till the
Sorry.
repayment
Yeah,
of
yeah.
the yes.
Till the repayment of
Yes.
Yes.
Till the payment required.
Yeah, till the repayment of interim finance.
Till the payment required.
Yeah, it is enough. It's fine.
Till the repayment of interim finance. This
Yes,
is okay,
that is
sir.
fine.
Yeah.
Okay.
Now, the amount repayable under sub-regulation, this will be considered any other cost incurred by the liquidator, which is essential for completing the liquidation process, provided that the cost, if any, incurred by the liquidator in relation to compromise or arrangement will not be considered as a form of the part of the liquidation cost. Now, preliminary report. So, what is the meaning of the preliminary report here? The preliminary report means the report prepared in accordance with Regulation 13. Progress report means the quarterly report prepared in
You will come in the
yes,
when
yes,
we read
yeah.
the regulations.
So, is there any other suggestions to any amendments in these definitions part?
That's enough.
Okay.
Madam,
Yes,
please
yes.
come a slide below, side up rather.
Slide below, na? So I'm sliding
slide.
below, sir.
Previous slide, ma'am.
Previous slide.
Previous.
Okay. Yes, sir.
Here it is liquidation cost means this cost incurred by the liquidator for preserving and protecting the assets.
Where it is mentioned, sir? In
Here
point
it is.
number?
Point number 4 and 5.
Yes,
Five
cost
about-
incurred by the liquidator for preserving and protecting the assets, properties, effects, and actionable claim, including secured assets of the corporate debtor. Yes, sir.
And after this 5
Yes,
is
yeah, cost
incurred
incurred by
in
the
carrying business.
liquidator in carrying on the business of the corporate debtor as a going concern. Yes, sir.
No, here my query is that
Yes,
that if a liquidator is trying to keep it as a going concern,
yes,
and if he has to get the material from the previous supplier,
yes,
and
That
previous
will be
supplier
part of
say,
that.
previous supplier says that first give me my last bill, only then I will supply. Like in electricity, electricity are something very essential for the plant.
yes, sir.
They say that you first give me the old payments, and only then I will do that. So will
Yes.
that old payment will be cost of the liquidation cost only?
No. That has to be part of claim.
But sir, some of the judgments are there. They provides that if for the going concern, if they have incurred any expenses for
During
doing,
liquidation.
during the liquidation for
That will be cost.
will be considered as the liquidation cost.
No, that is
Uh,
true.
yeah,
But for the
yeah.
periods before LCD, it forms part of the claim only.
Part of the you are
Claim.
saying
They have to lodge
yes,
claim.
yes, they will lose the claim, but still they will be considered as the cost as a liquidation cost.
No,
If anything will be incurred during the for carrying
during
on the going
liquidation, madam.
concern.
They
Yes.
are the operational creditor.
Example is that in our case,
Yes, sir.
suppose power company cuts my
Yes.
light, electricity,
Yes.
and they force me first pay my previous bill, only then I will start. So then that is required for
So-
the
No, no.
keeping business.
So-
No, then we can go to NCLT for
yes,
direction.
yes, for directions. Yes,
Okay,
I'm
thank you.
also suggesting this.
Thank you.
Suppose if it was running during CARP also,
Yeah.
even the CARP
Yeah.
period expenses as well as the liquidation
Essential,
expenses
yes.
becomes a part of liquidation cost.
Yes, and essentials supplies cannot be removed during the liquidation or the CIRP process.
We have
As
to,
yeah,
the NCLT has to be intervened then.
yes, NCLT will give the direction, definitely, sir. Now, regulation 2A, the contributions to the liquidation cost. So where the committee of creditors did not approve a resolution plan or approve a plan under sub-regulation 3 of regulation 39B of the IBC or CIRP regulations, the liquidator shall call upon the financial creditor, being financial institution, to contribute the excess of the liquidation cost over the liquidation assets of the corporate debtor.
Liquid assets, not liquidation assets.
Yes, sorry. Over the liquid assets of the corporate debtor as estimated by him in proportion to the financial debts owed to them by the corporate debtor. So basically, they will recover whatever the excess amount of the liquidation cost from the financial institutions only, na?
Initially.
Yes, yes. So they have also provided some illustration here that
Yeah,
40, the amount of debt if due 40 or 60 ratio to 4 have required to be contributed by the financial institution A, and 6 should be contributed by the financial institution B, and non-financial institutions there is
They need not.
no contribution. Yeah. So they have defined here is also. Now, by example, the contributions made under the plan approved under sub-regulation 3 of regulation 39B of the CIRP regulation, or contributions made under sub-regulation 1 as the case may be, shall be deposited in a designated escrow account to be open and maintained in the scheduled bank within 7 days of the passing of the liquidation order. So, yes, sir. You want to say something, sir?
No,
Yeah.
Yes.
May I?
Yes, sir.
See, if financial creditor is not any financial institution, it is an individual. And
Yes,
so
sir.
there is only one financial creditor, and that is an individual.
Yes, sir.
And others was operational creditor.
Yes.
No, we can't demand anything from.
He can't
Yeah.
demand, then what happened to the cost? Who will bear the cost? And if nobody we are ready to bear the cost, how the process will go on? Why the liquidator will do for free? Why the process will start? Why anybody will jump into such kind of scenario? Because it should be financial creditor.
Yes.
Financial,
Yes.
if there is a
So-
financial,
Yes.
the financial creditor is the main stakeholder. It is not the
Yes.
financial institution.
Hmm.
So what about that? Thank you.
Yes, sir. So you want to suggest something, sir? Have to make some change here? The
Yes,
financial creditor should be.
this
Yes.
the word financial institution should be replaced with the financial creditors,
Creditors.
because the whole process is to help the financial creditors,
Yes.
not the institution. The act is not for the institution only.
Hmm.
Even if there is no financial institute or financial creditor, there is only operational creditor, then what?
Hmm.
So for the cost, it should be financial creditor.
Yes, sir. Yes, sir. I'm writing
Or
down, sir.
or fine operational creditor, as the case may be.
Or stakeholder. Stakeholder will be endless.
No, endless. The person, main person. We are not talking endless. We are talking.
Sir,
Sir, but sir, they have also written here, the
Hmm.
liquidator shall call upon the financial creditors.
Being financial institution, what does mean?
No. So
If there is no financial creditor,
yeah,
That is what I am saying now.
yeah,
That
Or
is what I am
otherwise, we
saying.
can say in case there is no
Stakeholder.
financial creditor, the
What should be financial? What should be financial creditor?
creditors of non-financial can.
Financial
Yeah.
creditor or operational creditor, as the case may be.
Why not stakeholder?
No, stakeholders can be
sir,
other
no,
also.
sir, no,
Government
sir.
is also a stakeholder. Employees also a
Yes,
stakeholder.
yes,
The
yes.
entire
So
economy is a
they
stakeholder.
can't ask from the stakeholders.
So the person who is going to the beneficiary,
Or the SCC?
largest financial,
Shall all
this should
upon
be
the
financial creditors or largest operational creditor.
yes. So, sir, I'm just writing down here.
Financial
Shall,
credit. This should be financial creditors,
in
oblique,
case
oblique, largest operational creditors.
no, sir.
Or it can be
Please,
okay, not
yeah.
the credit committee of creditors. That's all. The one word will suffice.
Madam,
Instead of that.
I have
Yes.
Madam, I
Yes.
have a suggestion. Should be
Yes.
financial creditors
Yes.
or
Yes, ma'am.
or operational creditors in the absence of any financial creditors.
Thank you, ma'am.
Because if there are financial creditors,
Sir,
mostly
it
they
is
will
not
be the
about
only
financial.
beneficiary.
Madam, it is not financial creditor. It is financial institution.
Yeah, but
but
the financial institution, we are replacing it with financial creditors.
No, no.
So how to take the financial institutions in the picture, sir? So are we
Financial institutions will
No,
be included under financial creditors.
individual financial creditors. See, here you have to mention in the absence of any financial institution like banks, it should be from the individual financial creditors, not the operational creditors.
But if there are no financial
non-financial,
creditors, but if there are no financial creditors,
financial creditor of non-financial nature, non-financial institution nature.
but if there are no financial
it
creditors,
is a financial creditor, whether it's a financial institution or non-financial institution.
Yeah, but if there are no non-financial institutions and financial institutions are also there, the committee of creditors comprises only of operational creditors there.
No, that is okay, but first we have to decide whether non-financial institution creditors are also to contribute, not only the financial institutions. Then the other one is operating rate.
So what will be the exact wording of this regulation?
Upon,
yes, sir.
Liquidator shall call upon the creditors, put the creditors irrespective of whether financial, non-financial or operating.
Call upon the committee of creditors. Basically, they have
creditors forming part of the
because
consultation.
if there is no financial creditor, then automatically the committee of creditor will be considered as a whatever if they are financial creditor, or if they are not having the financial creditor, then automatically
instead of writing all those things, we can simply mention that shall call upon the creditors.
Which type of creditors, sir?
Creditors means everyone.
The committee of creditors, I think, sir,
creditors forming part of the creditors forming part of the stock.
There is no committee in the liquidation period. There is only stakeholders.
No. COC is there.
There is no committee of creditors.
Whoever
in the
is
case of flat owners, they are also being classified as a financial creditor. So then it may be a committee of creditor.
Whoever is the part of COC, they have to contribute. They will continue to be the stakeholders consultative.
There is no COC.
No, no, COC will be there, sir. Till SCC is formed. Till SCC, sir, till SCC is formed, COC will be there.
Yes.
Yes, and the voting right is also came in the liquidation process now.
Shall call upon the CO, Committee of
Committee of
Creditors.
creditors.
Suppose if there are only operational creditors as a part of committee, then operating creditors will also come.
Now, the contributions made under the plan approved under sub-regulation 3 of Regulation 39B of the Insolvency and Bankruptcy Board of India, CIRP regulation, as the case may be, shall be I have already read this. The amount contributed, the amount contributed under sub-regulation 2 shall be payable with interest at bank rate referred to in section 49 of the Reserve Bank of India.
It will be paid back to the creditors, Committee of Creditors.
Yes, with the interest.
That is nothing.
Now, explanation is here. It is hereby clarified that the requirement of this regulation shall apply to the liquidation process commencing or on or after the date of the commencement of the Insolvency and Bankruptcy Board of India, a liquidation process amendment regulation 2019. Now, compromise or arrangement. I think some new provision, new regulation was also inserted.
Notification is there.
In this page, there is no new notification. However, I'm reading this. To be the compromise or arrangement. Where the compromise or arrangement is proposed under section 230 of the Companies Act 2013, it shall be completed within 90 days of the order of the liquidation under section 33, provided that a person who is not eligible under the code to submit the resolution plan for insolvency resolution of the CD shall not be a party in any manner to such compromise or arrangement. So they have made it clear that they cannot become the party in the compromise arrangement also. Yes. Provided further that the liquidator shall file the proposal of the compromise or arrangement only in cases where such recommendation has been made by the committee under Regulation 39BA of the Insolvency and Bankruptcy Board of India, Insolvency Resolution Process of Corporate Person Regulation 2016. Provided further, the liquidator shall not file such proposal after expiry of 30 days from the liquidation commencement date. The time taken on compromise or arrangement not exceeding 90 days shall not be included in the liquidation period. Any cost incurred by the liquidator in relation to compromise or arrangement shall be borne by the corporate debtor, where such compromise or arrangement is sanctioned by the tribunal under this section, provided that such cost shall be borne by the parties who proposed compromise or arrangement, where such compromise or arrangement is not sanctioned by the tribunal under section 6 of section 230.
Madam, I want to say on regulation 2A.
Yes, sir. Yes, sir. 2B.
2A.
2A. Yes.
Yeah.
Yes, sir.
When in the case there is no financial creditor and only operational creditors are there, who will bear the liquidation cost?
So we have already written here the committee of creditors.
Yes.
So if no financial creditor, operational creditor will be considered as the committee of creditors.
Okay.
Compromise or arrangements, I have already read. Now the chapter 2, appointment and remuneration of the liquidator. Eligibility for appointment as a liquidator. So what is the eligibility criteria? Is the same which for the IP or IRP or RP. And insolvency professional shall be eligible to be appointed as a liquidator if he and every partner or director of the IPE of which he is a partner or director is independent of the CD a person shall be considered independent of the corporate debtor if he is eligible to be appointed as an independent director on the board of the corporate debtor under section 149 of the Companies Act, where the corporate debtor is a company, is not a related party of the CD, or has not been an employee or proprietor of a partner or of a firm of the auditor or secretarial auditor or the cost auditor of the corporate debtor, or of a legal or a consulting firm that has or had any transaction with the corporate debtor contributing 10% or more of the gross turnover of such firm in the last 3 financial years. The liquidator shall disclose the existence of any pecuniary or personal relationship with the concerned corporate debtor or any of its stakeholders as soon as he become aware of it to the board and the adjudicating authority. An insolvency professional shall not continue as a liquidator if the IPE of which he is a director or partner or any other partner or director of such IPE represent any other stakeholder in the same liquidation process. Now, liquidation fee. The fee payable to the liquidator shall be in accordance with the decision taken by the Committee of Creditor under Regulation 39D of the Insolvency and Bankruptcy Code of India, Solvency Resolution Process for the Corporate Person Regulation 2016, and where no fee has been fixed under Sub-Regulation 1. The consultation committee may fix the fee of the liquidator in its first meeting. And in case other than those covered under sub-regulation 1 and 1A, the liquidator shall be entitled to a fee at the same rate as the RP was entitled to during the CIRP process for a period of compromise, for the period of compromise or arrangement under section this, and as a percentage of the amount realized net of other liquidation cost and of the amount distributed for the balance period of liquidation as under. So the amount of realization and distribution they have mentioned. So how the percentage of the amount can be decided, they have mentioned here in first 6 months, next 6 months, and thereafter. So there is the percentage is given for the amount of realization and how much percentage is decided on the basis of realization.
There is one issue I
Yes.
want to ask. One
Yes.
issue I want to
Yes.
ask.
Yes.
In the past SCC,
In the
first SCC meeting,
first,
yeah,
yes,
SCC meeting,
first.
is the liquidator has to put an agenda for fees.
Liquidator can?
So the liquidator put an agenda.
Yes,
For,
yes,
for, is it
yeah,
mandatory? Is it mandatory?
yes, not. Sir, he should mention the fee at least, na, in each meetings, COC meetings also they have mentioned the fee. Yeah.
That is okay.
In
is
the
okay.
in consultation committee, yes, sir. How they will get the approval or how they will approve their fees, na?
By default, 3B will not come, na? The percentage one.
No, that is.
And because the end word is here, na, sir. So the
Ma'am,
fee, yes.
Madam, here one
Yes.
query there.
Yes.
Suppose there are one asset and that is under litigations, and the liquidation proceedings have already taken more than 6 years.
Yes, sir.
And even the financial creditor and the directors had not given possession to the liquidator or sale of that assets. There is only one single asset, single plot. And 6 years has been passed. In that case, at least the
yes, sir.
May I complete first, please?
Yes, yes, yes,
Yeah.
sir.
Because here the percentage here is given in under clause B.
Yes,
That
sir.
is as a percentage of the amount realized net of other liquidation cost. But here there are so many cases where the asset is there. Neither the bank nor the directors are handed over the actual assets and the litigation is going on. There are approximately 20 court cases pan India. In such cases, liquidators are suffering. Even the bank is not paying the liquidation costs and we are incurring liquidation costs from my own pocket.
So,
I
sir,
think
the NCLT is the only way
I agree.
Yes, yes, sir.
My suggestion is that
Hmm.
despite this percentage here, when we come to first, because this is after some time, in the old cases, in all liquidation cases which are prior to this amendment, in those cases, there were no provision for fixation of the liquidation cost. In those cases also, there should be some provision be made. In those cases, the SCC should fix liquidator cost fees at least within a period of 6 months, 4 months from the date of such amendment. That should be there.
Yeah.
Otherwise, it
Sir,
is.
now I think here they have also mentioned the fee payable to the liquidator shall be in accordance with the decision taken by the COC as per regulation of the CIRP regulation.
Yes.
So if your fees is fixed at the time of the meeting of the COCs in CIRP process, whatever is, suppose if you have taken the handover from the other IRP, still I think this regulation will be applicable and you can file your petition before the NCLT. However, if you want to suggest something in the regulation, you can provide the
My suggestion is there because this is there because this is after amendment, all the cases. Now, what is the status of cases which are prior to this amendment? Those liquidators are suffering.
Okay. So what you want to mention here, sir? Liquidators
Because
fee.
at least in old cases,
Sir, because the IBBI will ask where you want to put something or where you want to make any amendment in the regulation. So
here, ma'am, here 1A, where no
Yeah.
fees has been fixed under sub-regulation 1,
Yeah.
the consultation committee may fix the fees of the liquidator in the first meeting.
Yes.
Or in case of old cases, the
Here I think they should amend the shall. Means compulsorily they have fixed.
Here in
Because
Here-
may word is used here. Here I think also required a one change. Shall.
Yes, it shall will be better, ma'am.
Mhm.
And
Now,
That is why I asked about
Yes.
the general.
No,
That
if
is
you are
why
putting
I
shall,
asked.
next
Yes.
point will not be valid. Point number 2. In case
And-
other than those covered
and
under
in case of
sub-regulation,
old cases,
liquidators shall
prior
be
to this
entitled to a fee.
amendment,
Sir, please one by one, sir. I'm not able to listen. Yes,
in
sir.
case of old
See,
cases, ma'am,
If
prior
you
to
put
this
shall
amendment,
here, the point number 2, which says in cases other than those covered under sub-regulation 1 and 1A,
Yeah.
liquidators shall be entitled to a fee at the same rate.
Yes.
So we may put may only because all if you put the point number 2, actually,
Yeah,
regulation
okay.
2 will get
Okay.
not
Okay.
valid.
Got it. Got it. Got it. Yes, sir. Yes, sir. Now continue, sir. Something you were saying, sir?
yes, ma'am.
Yes.
I am talking about, ma'am, cases which are prior to this amendment.
Yes.
Because these sections, regulations are not applicable on those cases. Suppose liquidation order was passed in February, March 2019, ma'am. I have already filed application before the Honorable Adjudicating Authority that was also disposed of,
Okay.
stating that these regulations are not applicable on those cases.
Okay.
And we are incurring liquidation expenditure from the last 6 years.
Okay. Yes, sir.
And no fees is paid. I have put my agenda before the SEC. They are saying we will pay as per rules. Where I have to go? I have requested them. Then you change the liquidator, put the some name or some other IP from your empanelment. They are not doing that also. Where we have to go, ma'am? I have requested to the IBBI. They say the power is not.
Sir, have you filed your resignation before them?
Why I should file my resignation, man?
Okay, your
Why I
fees is
should file my
pending.
resignation?
Okay, your fees is pending.
Why if
No.
bank has filed the Section 7 application, bank has made the proper calculation because they are the proper professionals. Why the liquidators should suffer? IP should suffer?
Sir. Yes, sir. Now I understand. You please mention what you want to make change here in this
The
regulation.
liquidation fees in case of cases started prior to applicable of these regulations. Actually, some monthly fee should be there in cases where there is some litigation is there is no asset, there is some suppose debtors and some minimum
Yes,
asset
sir.
is there.
Yes, sir.
Sometimes there is
Sir,
only 2 lakh
yeah.
asset is there.
Yes, sir. Yes, sir. Continue. The liquidation fee started prior to the amendment of this regulation.
Regulations, yes, please.
Hmm.
May kindly be shall be fixed by the SEC at least within a period of 2 months, 1 month from this amendment, so that the SEC should be bound to fix the fees of the liquidator. Or in case of insufficient assets, so the liquidation is going on for 6 months and there is only 1 lakh assets, how the liquidator will work?
Madam,
Yes, 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 sir. Yes,
one suggestion is there.
yes, sir.
Please give it an upper page. Yes.
Yes.
To removal of first word means SEC means in 1A, the consultation committee may fix the fee of the liquidator in its first meeting. By first only. Because first meeting is to be held within 1 week of the liquidation commencement. So first word should be removed.
What, sir?
Means in any meeting, SEC can fix the meeting.
No,
No, sir.
No. It is based on realization.
Yes, sir.
It is based on realization.
Yes,
This is
And
perfect, sir.
realization
This
and
is
disbursement.
perfect. Yes, sir. This is perfect, sir.
Yes.
Why first meeting only?
Sir,
Why not
because
in second meeting?
sir, at least in the first meeting, they should decide the fees. Na? Otherwise, they will not decide the fees
Yes, what is happening with me?
later on also.
But in first meeting, they may say that we have to take a decision and all that. We will discuss it in next meeting and all that.
Therefore, I'm saying shall may
Yes,
should be
Because
replaced with the shall.
the problem there is bankers, they can't decide themselves who is attending the meeting. So they will take their for taking the approval, they will go back and send, decide it in the next meeting. That is the issue. Bankers who is attending the meeting or who are attending the meeting, they may not be able to decide on the spot the liquidation expenses payable to the.
But sir, I have seen some of the cases in which they have not decided the fee of liquidator or IRP till 3, 4, 5, 6 meeting have already gone.
Ma'am, you see section
That
31.
is objectionable. That is
Yeah.
objectionable.
Ma'am, can you see
Because in the first
section
meeting,
31?
if it cannot be done, it has to be done in the second
No,
meeting.
madam, in that case, this schedule will be applicable if it is not decided.
Madam, kindly refer section
Regulation,
31A.
yes, this
Hey,
schedule.
that is only tentative, na, sir, because we have the value of the assets on hand from the balance sheet or from wherever. Based on that are the valuation reports. Based on that, some tentative figure can be fixed as the liquidation, expenses payable to the liquidator.
Madam, section 31A.
Yes,
Regulation 31A.
Yes,
Kindly
sir.
refer regulation 31AC. Regulation 31.
Yes, sir.
Yes.
C. Fee of the liquidator.
Fee of the liquidator.
They can do in any meeting.
No, that is the liquidator shall constitute the consultation committee comprising of not any meeting, sir. It is the first meeting.
No.
60 days from the liquidation commencement.
Please go down.
Based on the
No, sir. This para belongs to stakeholders consultation committee. The liquidator shall constitute a consultation committee comprising of all creditors of the corporate debtor within 60 days from the liquidation commencement date, based on the list of the stakeholders prepared under the regulation, to advise him on matters relating to remuneration of professionals.
So this is only for the what is required to be discussed. Means
No,
basically,
madam. Within 60 days, the SEC will be formatted.
Exactly.
And then in any meeting, it can be done. What Suresh has said, yes, perfectly correct.
Yes.
It can be done in any meeting, yes.
Ma'am, my suggestion is that CIRP, a mandated schedule of fees should be mentioned, as the contingency of realizability of asset is, very, very uncertain.
Definitely.
So there should be a fees, definite fees as mandated in the case of, there should be a schedule of fees as mandated
Sir,
in case of
already
CI.
written here at the same rate, whatever is charging the RP will be given to the liquidator.
ARP.
Yeah.
No, but in the old cases it is not. And
Yes, so I have mentioned, na, sir have
and
already the
when the matter is
liquidation fee
and when the
started
matter is
prior to.
referred to the NCLT, now I have was running a liquidation process. The NCLT has not taken decision in 4 years.
Yes, sir, I have written, sir, I have written this.
Madam,
This,
RP is only for compromise cases, not all
Yes.
cases.
I have
Equivalent,
written this.
that RP is only for compromise cases.
Which one?
Sir,
RP is,
yes, sir.
as per the RP is, that is only for the compromise.
Yes, that is only for compromise, not in the normal liquidation.
Yes.
Okay, you are saying ki if there is compromise or arrangement,
Only in
only
that
then
case.
they have provided here.
Yes.
But here they are saying na fee payable to the liquidator shall be in accordance with the decision taken by the COC.
That is last COC during CILP.
Yes. So whatever the fee payable to the liquidator shall also be decided by the COC.
Yes, last COC.
Ma'am, in
During
that
CILP.
liquidation, when the liquidation was recommended, COC did not fix the fee. And
So,
later on also, in the
yes.
stakeholder, they did not, in the first meeting or in the first meeting itself, they did not fix the fee.
So sir, what is the changes you want to?
Changes is there should be a mandated schedule of fees for the liquidator also, as in the case of CIRP for the IP or IRP.
Madam, may I suggest?
In all the cases.
In all cases.
In all the cases.
Madam, may I suggest?
Yes,
Old and new
yes,
both.
sir. Yes, sir. Please, sir.
Yes, it is Regulation 2.
Yes.
At the same rate as the resolution professional were entitled to during the corporate insolvency process.
But
यहाँ
sir,
तक रखे
here-
इसकी बाद वाला जो वर्ड है वो
Yes,
हटाते हैं
yes,
resolution।
yes.
No, and please keep it a minimum. Minimum the fee.
Minimum
minimum
cap,
तो आ ही
yeah,
जाएगा ना उसमें।
there should be.
Rather, fee of the RP may be the fixed one. That means that much amount is to be given, irrespective of the asset.
Yes.
Or whichever is higher, we can say.
Okay. Now noted. We'll move on the next regulation. The reporting. The liquidator shall prepare and submit the preliminary report, asset memorandum, progress report, sale report, minutes of the consultation with the stakeholders, and the final report prior to the dissolution to the adjudicating authority in the manner specified in this regulation. In these regulations, the liquidator shall preserve a physical as well as electronic copy of the reports and minutes referred in this for 8 years after the dissolution of the CD. And subject to other provision of these regulations, the liquidator shall make the report and minutes referred to sub-regulation 1 available to the stakeholder in either electronic or physical form on receipt of an applicable application in writing. The cost of making such report and minutes available to it, and an undertaking from the stakeholder that it.
Madam, your voice is very low, madam.
Am I audible? Other contestants.
It's audible, but it's very low voice.
Yeah. You are audible, madam.
Okay. Sir, maybe some problem in your device. Please check, sir. The cost of making such report and minutes available to it, and an undertaking from the stakeholders that it shall maintain confidentiality of such reports and minutes and shall not use those to cause an undue gain or undue losses to itself or any other person. So is there any change required in this regulation? Now move on. The registered and books of accounts, where the books of account of the CD are incomplete on the liquidation commencement date, the liquidator shall have them completed and brought up to date with all convenient speed as soon as the order for liquidation is passed. The liquidator shall maintain the following registered and books as may be applicable in relation to the liquidation of the CD and shall preserve them for a period of 8 years after the dissolution of the CD. Cash book, ledger, bank ledger, all these registers they have mentioned here. So is there any other register or any other books you want to added here? You can suggest. The register and books and under subregulation 2 may be maintained in the forms indicated in Schedule 3 with such modifications as the liquidator may deem fit in the facts and circumstances of the liquidation process. The liquidator shall keep receipts of all the payments made or expenses incurred by him. Now, appointment of professionals.
Madam, I have one question.
Yes, sir.
Prior to liquidation, the record has to be kept for which period?
Sir, 3 years for the if electronic, or 8 years, I think, also for the CI physical.
No, 3 years physical, 8 years electronic.
No, sir. I don't think so. Maybe, sir. I'm wrong on it.
Records are records, but what is the difference?
Sir, your voice is not coming, sir. It's breaking, sir.
8 years after dissolution.
The
8
records are
years after
records. Why
dissolution.
the difference between electronic and physical records?
Because
Regulation
you-
5.2. Regulation 5.2.
As per regulation 5.2.
Yes. Physical as well as electronics for 8 years.
Okay. Okay. Thank you, sir. Physical for 8 years, no, sir?
Physical as well as.
As well as electronic, both.
Yeah, yes.
Okay.
What I am asking is why the difference? Okay, 5.2, but why is the reason for the difference?
Because in this regulation there is no difference, sir. They have saying ki have to maintain 8 years only.
This is after dissolution.
After the dissolution and before the dissolution.
After, yes. Okay. You are saying before the dissolution?
Dissolution, yes.
Okay. I think there is a because later on we'll read some other regulations, sir. But still I have also no idea.
The liquidation will lead to dissolution, or else liquidation will be cancelled. Liquidation, if everybody withdraws, the liquidation will be cancelled. Otherwise, liquidation leads to dissolution only.
The registers and books under subregulation 2 may be maintained in the forms indicated in Schedule 3 with such modifications as the liquidator may deem fit in the facts and circumstances of the liquidation process. The liquidator shall keep receipt of all the payments made or expenses incurred by him. Now, appointment of the professionals. The liquidator may appoint professionals to assist him in discharge of his duties, obligations, and functions. The liquidator shall not appoint professionals or under subregulation 1 who is his relatives or the related party of the corporate debtor or has served as an auditor of the CD in the 5 years preceding the liquidation commencement date. The professional appointed or proposed to be appointed under subregulation 1 shall disclose the existence of any pecuniary or the personal relationship with any of the stakeholder or the concerned corporate debtor as soon as he become aware of it to the liquidator. Now, consultation with the stakeholders. So, stakeholders consulted under subsection 35(2) shall extend all assistance and cooperation to the liquidator to complete the liquidation of the corporate debtor. The liquidator shall maintain the particular of any consultation with the stakeholders made under this regulation as specified in Form A of Schedule 2. Now, personal to extend the cooperation to the liquidator may make an application to the adjudicating authority for a direction that a person who is or has been an officer, auditor, employee, promoter, or partner of the CD was the interim IRP, RP, or previous liquidator of the CD, or has possession of any of the properties of the CD, shall cooperate with him in collection of the information necessary for the conduct of the liquidation. An application may be made under this regulation only after the liquidator has made reasonable efforts to obtain the information from such person and failed to obtain it. So, is there any change required in these regulations? Now, disclaimer of owner's property. Where any part of the property of the corporate debtor consists of land or any tenure burden with the owner's covenants, shares, stocks in companies, any other property which is not sellable or not readily sellable by reason of the possessor thereof being bound either to the performance of any onerous act or to the payment of any sum of money or unprofitable contracts, the liquidator may notwithstanding that he has endeavored to sell or has taken possession of the property, exercise any act of ownership in relation thereto, or done anything in pursuance of the contract, make an application to the adjudicating authority within 6 months from the liquidation commencement date or such extended period, yes sir, as may be allowed by the adjudicating authority to disclaim the property or contract. The liquidator shall not have shall
मैडम
not
इसमें
make
6 months के जो कंडीशन है ये इसको
Yeah.
रिमूव करना चाहिए
within 6 months. So what
हाँ.
should be there, sir? So when the liquidator will make this application? So
Make
some
an application to
time
the adjudicating
timeline should
authority.
be there, na sir? Because IBC is the time bound. So IBB will also ask ki what
It,
will be the sufficient time for making
it,
such
it should be from the date of default.
from the date of default.
Yeah.
From the date when the liquidator come into the
No,
come in the
no.
yes.
Sometime the default is from the previous period, and the process starts much later. But in the meantime, there are a lot of transactions which happens, and that by the time it comes to liquidation, nothing is left.
No, sir, this is not for that. This is the regulation for the disclaimer of onerous property. So here the liquidator have claimed their disclaimer on the onerous property which is not suited to them. They will in the only on in this case the liquidator can ask for the disclaimer on this type of property which is unprofitable to the company. So
They
here,
make the property
so
onerous after the default, but before the this liquidation and all that.
Or adjudicating authority may be removed, and in place of adjudicating SCC may be substituted with the permission of SCC.
6 months from the liquidation commencement date or such extended period
Time and may be allowed by the SCC.
Sir, because the major decision because the leftover or the property is how the SCC will take the decision, because if some interest is involved in the property and the liquidator was misguidedly maybe they have take the action that this is unprofitable contract or something. So in
That's
this
not
case,
very, that's not very
if
time frame.
yeah, so if the third party interest is involved, then then it should be allowed only through the adjudicating authority, not through the SCC, sir.
That's not very time frame.
Mhm.
It can be filed any time during liquidation.
But sir, if we will not restrict within the time, within 6 months, so they will take 1 year or 2 years to
Yes.
this.
Many times it takes time to get to know. Many times, once you get, it takes time to take position. After that, this kind of things may come.
12 months may be mentioned.
Sometimes what happens, liquidator came to know after 12 months or after a long time, some property is also there.
12 months may be mentioned.
Then they can go for extension. That provision is there. such extended period.
Yes, yes.
So why should we keep
Yes,
say 12
yes.
months?
Yes.
Yes, it is there.
A person is interested in the owner's property or contract if he is entitled to the
If
benefit
it is
or
within 6 months,
yes,
it may be 3 months also.
yes,
Within 6 months, that doesn't mean it is on the exactly 6th month. It can be before 6 months also, and for the period extended.
yes,
So nothing wrong in that.
yes. Or claims an interest in the disclaimed property or is under the liability not discharged in respect of the disclaimed property. Subject to the order of the adjudicating authority approving such disclaimer, the disclaimer shall operate to determine from the date of the disclaimer the rights, interest, and liabilities of the CD in or in respect of the property or contract disclaimed, but shall not accept so far as necessary for the purpose of releasing the corporate debtor and property of the corporate from liability, affect the right, interest, and liability of any other person. The person affected by the disclaimer under this regulation shall be deemed to be a creditor of the CD for an amount of the compensation or damages payable in respect of such effect and may accordingly be payable as a debt in liquidation under section 53 subsection 1 F. Now,
Other
yes, other as required to be paid in the waterfall mechanism.
Yeah.
So how can they take the consultation stakeholders consultation committee as earlier some of the participants have suggested? So they should be only through the adjudicating authority because of this point also. So exhaustionate credit transactions, the transaction shall be considered an exhaustionate credit transaction under section 50 subsection 2, where the terms requires the corporate debtor to make the exorbitant payment in respect of the credit provided or an unconsignable under the principle of law relating to the contract.
Yeah, I think this
Sir,
para is
this
not required.
Sir, this para is mentioned in all the regulations.
Yeah.
Yeah, I have seen
It's
all
only
the
for this.
regulations.
Because it is covered already under that
Yes,
avoidance
already.
transaction section,
Yes,
43,
yes.
44, 45.
Yes. So, however, they have mentioned in all the regulations. Now, chapter 4 is started. The public announcement by the liquidator. So, the liquidator shall make a public announcement in Form B of Schedule 2 within 5 days from his appointment. The public announcement shall call upon the stakeholders to submit their claims or update their claims submitted during the CIRP as on the liquidation commencement date and provided.
Excuse me, a small this. For the information of everyone, there is a circular dated 28th September 2023, where in the IBB has given lot of clarifications about the liquidator's fee.
Okay.
That is a circular of about 4 pages.
Okay.
So I think mostly
on the IBBI website, this is mentioned, sir.
Yeah,
So we'll
it is there in
see.
yeah.
Okay.
I'll tell you the number also. IBBI./lic/61 date of 2023.
1 minute. I just share with the participants also na here.
Yeah.
Because if we are discussing everything, so we should discuss the proper.
I am mentioning in the chat box.
Okay. Okay, sir. Please mention.
Yeah.
Okay, sir.
You carry on,
mentioned.
madam. Carry on.
Yes. So 5 days is given for the public announcement, and provided that where the stakeholder does not submit its claim during the liquidation process, the claim submitted by such a stakeholder and duly collected by the IRP or RP as the case may be during the CIRP process shall be deemed to be submitted under section 38. Announcement shall
Madam,
be
there
published.
is
Yes, sir.
Belated claims it has not been mentioned.
Sir,
like CIRP. If any person is not able to submit his claim within
It
30
will
days.
extinguish. There is no chance.
No, sir. They can submit their claim during the liquidation, sir. If any person, whoever is not submitted their claim in the CIRP or CIRP process, they can submit in the liquidation.
No,
Now,
if they are not able to submit within the 30-day period, then
the sir, some condonation of delay cases are also there.
but it has not been provided in the regulation.
Regulation, sir, something is depend on the case to case basis, so they cannot mention in the regulations.
No, like
So
CIRP, there is condonation of delay. Here it also should be mentioned.
Sir, the section 41 is also applicable for the filing of the claim in the liquidation also, sir. If there is any appeal, if anyone want to go in the appeal against the liquidator or the IRP or RP decisions, they can go.
Which one? Section?
41, sir.
Section 41.
Yeah. The announcement shall be published in one English and one regional language newspaper with wide circulation at the location of the registered office and the principal office, if any, of the CD, and any other location where, in the opinion of the liquidator, the CD conduct the material business operations on the website, if any, of the CD, and on the website, if any, designated by the board for this purpose. Now, process email ID. The liquidator shall operate the process email account handled over to him by the RP in accordance with the regulation 4C of the IP insolvent CIRP regulation, and in the event of his replacement, the credential of such email ID shall be handed over to the new liquidator. So this is important. Preliminary report. The liquidator shall submit a preliminary report to the adjudicating authority within 75 days from the liquidation commencement date, detailing the capital structure of the CD, estimates of the assets and liabilities as on the liquidation commencement date based on the books of the CD, provided that if the liquidator has reason to believe to be recorded in writing that the books of the CD are not reliable, he shall also provide such estimates based on the reliable records and data otherwise available to him. Whether he intends to make any further inquiry in any matter relating to the promotion, formation, or failure of the CD or the conduct of the business thereof, and the proposed plan of action for carrying on the liquidation, including the timeline within which the proposes to carry it out, and is estimated the liquidation cost. Early dissolution, any time after the preparation of the preliminary report, if it appears to the liquidator that the realizable properties of the CD are insufficient to cover the cost of the liquidation, and the affairs of the CD do not require any further investigation, he shall consult the consultation committee, and if it advise for only early dissolution, he may apply along with the detailed report, including incorporating the views of the consultation committee to the adjudicating authority for the early dissolution of the CD and for the necessary direction in respect of such dissolution. Now, progress report. The liquidator shall submit the progress report in the format stipulated by the board to the adjudicating authority, and the board as under the first progress report within 15 days after the end of the quarter in which he is appointed, and subsequent progress report within 15 days after the end of the every quarter during which he acts as a liquidator, and provided that if the IP ceases to act as a liquidator during the liquidation process, he shall file a progress report for a quarter up to the date of his so ceasing to act within 15 days of such cessation, and the progress report shall provide all information relevant to the liquidation for the quarter, including the appointment, tenure of the appointment, cessation of the appointment of the professionals, statement including the progress in the liquidation, including the statement in the stakeholders details of any property that remains to be sold and realized, distribution made to the stakeholder, and distribution of the unsold property made to the stakeholders, details of fee or remuneration, including the fee due to or received by the liquidator, together with the description of the activities carried out by him, the remuneration of fee paid to the professional appointed by the liquidator, together with the description of activities carried out by them, other expenses incurred by the liquidator, whether paid or not, developments in the any material litigation or by or against the CD, filing of and developments in applications for avoidance of transactions under this part of the code, and charges if any is estimated liquidation cost, changes if any in the estimated liquidation cost. A progress report shall enclose an account maintained by the liquidator showing his receipt and payment during the quarter and the cumulative amount of his receipt and payment since the liquidation commencement date. The progress report shall enclose a statement including any material change in expected realization of any property proposed to be sold along with the basis of for such changes. The progress report for the fourth quarter of the financial year shall enclose the audited accounts of the auditor, liquidators, receipts and payments for the financial year. So provided that in case the IP ceases to act as a liquidator, the audited accounts of his receipt and payment for that part of the financial year during which he has acted as liquidator shall be enclosed with the progress report to be filed after cessation of his appointment.
Madam, whether audit is required for the earlier period, which has not been completed during CIRP or.
So they have said ki whatever if they have seizes and the quarter, the fourth quarter.
No, it's
was
okay, but
yes.
in normal circumstances, whether the liquidator is required to obtain the audit reports for the earlier year, if no audit has not taken place in earlier years.
Sir, here they said audited accounts of liquidators, receipts and payments.
Yeah.
Here they have not said ki financial statements auditor report is required. They have said audited accounts of the liquidators, receipts and payment. Whatever what amount they the liquidator have received during the liquidation period and what amount they have paid during the liquidation period, only for this account they have required to be audited.
And I want to go to early resolution, early liquidation process.
If early liquidation process is there, so whatever, suppose if you are saying ki if early dissolution was there, in case the early dissolution was there, so whatever the period for which till the time the liquidation is going on, will make the progress report and will also audit it if last quarter accounts of the receipt and payments.
And madam, can if there is COFA application is pending, can there be early resolution?
Sir, if application is already pending before the NCLT, so how can we say ki the dissolution is completed? Only after passing the order from the NCLT, the dissolution will be completed, na sir?
In that case,
in this case, you have to file your report regularly, sir. In this
no,
case,
I want to
yeah.
refer to the early resolution.
Yes, you have
regulation.
filed. Yes, you have early regulations.
Early resolution.
Early dissolution.
Yes.
So if you have filed the early dissolution, in that case also you have required to file your regular report, whatever is required as per the regulations.
Sure.
Only
As
after
regard-
passing the order from the NCLT, you have to stop.
Can we go to the early resolution clause? Regulation?
Yes, early dissolution you can go because it is specifically mentioned.
But if there is any COFA application is pending, can we go for the early resolution?
Sir, they have only mentioned if there is no assets.
Yeah.
If there is COFA, then how it can
Because Because
Ma'am, I
yes,
have a
sir.
different view in this.
Yes,
Even though
yes.
if you have a PUFA application,
Yes, sir.
you can still go for a dissolution. Before
Yes.
filing a dissolution application, you have to take a call who will do
Yes.
the proceedings, who will take care of the proceedings. So if the SEC members is ready to take care of the proceedings in
Yes.
NCLT, then you
Yes.
can go for dissolution, and there is
Because
specific things mentioned in the
yes, because buffet transactions will be distributed among the basically FC. So basically they have to take the call on this.
Yes, though the call has to
Yeah.
be taken by SEC, but what
Yeah.
challenge we have seen, madam, in
Yes.
one of the case we have got a favorable order in January 24, and now we are in June 25. So
Okay.
initially they filed appeal in NCLAT, then they lost. Then after that also they have not paid. Then we filed execution application and contempt application in NCLT Kolkata, and still the matters are going on for such a long time. And
Okay.
even after 1.5 years, we are not sure what will be the recovery.
Sir, there is a regulation 44A. I'll just read it out. Treatment of
Okay.
avoidance transactions. The liquidator shall, on the advice of
Yes. Yes, sir. Yes, sir.
consultation committee, provide in the application, along with the final report filed under Regulation 45, for the manner in which proceedings in respect of avoidance transactions, if any, under Chapter 3 are fraudulent or wrong trading under Chapter 6 of Part 2 of the Code, will be pursued after the dissolution or closure of liquidation process, and the manner in which the proceeds, if any, from such proceedings shall be distributed.
I was referring to this regulation only.
Yeah,
Yes.
44A. So dissolution need not be stopped for
Yes.
want of settlement of avoidance transaction.
Yes. These are the where we are. Yes, we have discussed the progress report and what is required to be in the progress report. Now submission of claim, we all know in which form have required to be submitted by OC, by FC, because there are so many pages in this regulation and only half an hour left. So we will also discuss what is the new amendments, because you all know these regulations. Let's see some amendments, whatever is came recently. So this is came inserted on 28th January 2025. I will show you.
79.
Yes, 79. So from the beginning, we will see this.
That is
Final,
there, 37.
Final report prior to the dissolution. Basically, this is related to this. So what is written here? The closure of the liquidation process of the corporate debtor, where the corporate debtor is sold as a going concern, or a compromise or arrangement has been sanctioned under Section 230 of the Companies Act. So basically, this change came here. So what is the impact of this? When the corporate debtor is liquidated, the liquidator shall make an account of the liquidation showing how it has been conducted and how the corporate debtor's asset has been liquidated. If the liquidation cost exceeds the estimated liquidation cost as provided in the preliminary report, the liquidator shall explain the reason for the same. The liquidator shall submit an application along with the final report and the compliance certificate in Form H to the adjudicating authority, for which purpose now they have said closure of the liquidation process of the corporate debtor, where the corporate debtor is sold as a going concern, or compromise or arrangement
Under
if
Section
they,
230.
So this is the only change came here.
So earlier they didn't mention 230.
Only
they said as a sold as a going concern.
Yes. This was also substituted. So I will show you the 82. the corporate liquidation account. So the board shall maintain and operate an account to be called the corporate liquidation account with the scheduled bank. So scheduled bank is earlier they have mentioned here.
Earlier in the public accounts
public
of India.
accounts, yeah, public accounts of India. Earlier
Now
this
made it
was,
with scheduled bank.
yeah. So now this is with the scheduled bank. And this is inserted by the new 29th January 2025. 95. So this is basically filing of forms, because earlier no forms was prescribed, I think, for the liquidation of something. So these new forms have been prescribed for this purpose. The liquidator shall file the forms along with the enclosures thereto on an electronic platforms of the board as per the timeline stipulated against each form as per the table below. So liquidation one form. Yes, sir.
Now, since CP forms have changed, I think they likely form there may be a
Yes,
change in
yes. CP forms was there earlier, CP4, I think. But now this is the liquidation one form from the liquidation commencement date till the public announcement. This includes details of the liquidator, corporate debtor, the liquidation fee, etc. on or before the 10th day of the subsequent month. So this required to be filed on or before the 10th day of the subsequent month after the public announcement has been made. From liquidated to from public announcement till progress report. So this include details of valuation, sale, litigation, avoidance of transaction, meeting of consultation committee, receipts and payment on or before the 10th day of the subsequent month after submission of each progress report to the adjudicating authority. So I think this is quarterly form, because quarterly required to submit the full report. So each subsequent month have required to file this form also. From final report to application for dissolution, this include details of unclaimed proceeds, sale, litigation, avoidance, transaction, realization, distribution of proceeds, receipts and payments. So on or before the 10th day of the subsequent month after the submission of the dissolution closure application to the adjudicating authority. From application for dissolution to order of dissolution, this include details of the distribution of proceeds, receipts and payments on or before the 14th day of passing of the order for dissolution of the CD or closure of the liquidation process by the adjudicating authority. So these new forms was came, and this is omitted basically. So what is omitted? Section 98, 97, because 97 is omitted. So here they have mentioned this was mentioned earlier, but now it is deleted. The liquidator shall provide at least 14 days from the issue of the public notice for submission of eligibility document by the prospective bidder. So because this is, I think, the eligibility criteria, the auction or the auction, this is the regulation basically. This is the schedule 1 mode of sale basically for the auction, and here this is deleted. The 1D, earlier there is 1D, but now this is deleted. But there is a change also came as per 98 substituted on 28th January 2025. So what is provided as per this? The liquidator shall provide to the prospective bidder access of the assets under auction to facilitate their inspection and due diligence. But earlier, what is mentioned here, prior to the substitution, it stood as the liquidator shall provide the qualified bidder. Now, not qualified bidder, this is the prospective bidder. The word is the prospective bidder. At least 7 days. 7 days was also mentioned earlier, but now they have mentioned access to the asset under auction to facilitate their inspection and due diligence. So time is not mentioned here. at least 7 days for the inspection or due diligence of asset under auction from the date of declaration of the qualified bidder. So, basically this terms was also changed. Now this is inserted, 103, newly inserted. The public notice shall state that prospective bidders shall submit an undertaking that they do not suffer from any eligibility under section 29A of the code to the extent applicable, that it found ineligible at any stage, the earnest money deposit shall be forfeited. So the person who has not submitted their eligibility and they are suffering from the ineligibility, then their amount can be forfeited. This is also mentioned here. Now, this is also newly inserted, 107. Within 3 days of declaring the highest bidder, the liquidator shall conduct the diligence and verify the eligibility of the highest bidder. So within 3 days is provided for of declaring the highest bidder. Liquidator shall conduct due diligence. So due diligence period is also provided here to verify the eligibility of the highest bidder for the liquidator. This is 124 is also substituted. So the form basically here, and this form, in this form, this new, some new tables are inserted. So these 3 tables are inserted. Applicable section of Income Tax Act 1961 or any other law under which the tax is to be deducted have inserted, amount of tax to be deducted inserted, reason for unclaimed dividend or distributed proceeds. These are newly inserted in this table. So whatever the new changes have I have mentioned. Now is any suggestions in this regulations?
Ma'am,
Yes.
regarding
So
this,
specific, yeah.
regarding the voting, pattern in the
Yes.
SEC meeting,
Sir,
that
now
that
they have decided the 66% voting is required for some of the matters.
yeah,
Liquidation also.
but
Yes.
in our case, we are not able to take any decision because now the operational creditors also are given the voting share.
Yes.
As per the new SEC. And in
It is
our
a
case,
service
major portion is of the operational creditors who do not, they are government dues and they do not vote. They just abstain. So my suggestion is that only those who participate in the meeting and vote, the percentage should be calculated from those numbers.
Sir, the percentage is only given for some matters, and this is 60% of the COC, because I will also read the regulation, whatever the regulation is provided for this. 1 minute, sir. I'm reading this regulation.
31,
31A, I think it started from here, na, sir? The liquidator shall constitute a consultation committee comprising of all the creditors of the corporate debtor within 60 days from the liquidation commencement date, based on the list of stakeholders prepared under Regulation 31, to advise him on matters relating to the remuneration of the professionals appointed under Regulation 7, sale under Regulation 32, including manner of sale, advise. Here they have used only the word advise him on the matter relating to. So stakeholders committee, the whatever the stakeholders committee here, they only advise. Now the decision making authority is still the liquidator only in these cases. The remuneration of professional appointed under this regulation, sale under Regulation 32, including manner of sale, pre-bid qualification, reserve price, marketing strategy and auctions process, Fee of liquidator, valuation under sub-regulation 2 of regulation 35, the manner in which the proceeding in respect of the preferential transaction, undervalued transaction, extortionate credit transaction, or fraudulent wrongful trading, if any, shall be pursued after closure of the liquidation proceedings, and the manner in which the proceed, if any, from those proceedings shall be distributed. Reviewing of marketing strategy in case of failure of sale of the corporate debtor as a going concern, continuation or institution of any suit or legal proceeding by or against the ceding, extension of payment of balance sale consideration as provided in clause this beyond the 90 days to be disclosed in the auction notice. So advice is required. The committee of creditor under section 21 shall function as the consultation committee with same voting right till constitution of the consultation committee under sub-regulation 1. Now, the voting shares of the members of the consultation committee shall be in proportion to their admitted claim in the total admitted claim.
The problem is there.
Yeah.
Problem with this, yes.
Yes, sir.
31,
Yes.
31A2.
Yes, 31A2. So what is the problem, sir? So
Actually,
what is the solution?
Means if OC or other stakeholders are not going to take any benefit or will not be eligible for a single of rupees, then their voting share should be removed from SCC member. Else, what happened? They hijack the whole proceedings.
Yeah, yes,
They
yes.
do not allow liquidator to work over there.
Yes.
It is very big problem because they are not going to take anything, and they may be under pressure of any of the failed auctioneer or failed bidder, and they will create so many problems.
May I?
Yes, sir. Yes, sir.
Sir, first thing from the beginning, this section is mandatory. It is not, it leaves nothing for the liquidator to work on his own. If you read from the first, go up. Yes. 31(1). Liquidator shall constitute. That means constitution committee is mandatory. Taking their purposes advice. It is not just constitution of the committee. Constitution of committee for the purpose to take advice. Advice is also mandatory. He has to act as per the advice given, as per the norm settled, not agreed upon. No, liquidator cannot do anything on his own.
Sometimes
everything is mandatory. Nothing.
Yes.
There is nothing that he can do on his own. Number one. Number two, stakeholder are the creators. They are the major stakeholders. So they have every right to decide in what manner, to whom, to whatever has to be, liquidation has to be in that way, because they are paying even the cost of liquidation also. So see the whole scheme. It cannot say, I cannot say that, okay, I'm a liquidator, I can do this, and I do as per my convenience. No.
But
Please understand.
they are saying for the
is not of
operational. They are
Please.
saying for the
What is the
operational
question?
creditor.
What is your
Question
question,
is
Mr.
that
Rajesh?
liquidator is not able to proceed further in the matter as major portion of voting is held with the operational creditor who are not to get anything, and they don't vote.
Kindly go to the last point.
Sir,
Kindly go to the last point.
Purpose of this is to liquidate first, not the manner. The manner already, how the proceeds of, what will be the distribution process, that is already defined. Distribution will be as per that provision.
We are not talking about distribution.
Then you say no.
Voting percentage.
You are saying that they are not going to get anything. They are not going to get anything. Mean what? You are talking of the distribution.
Sir,
no. I am talking about the
Sir,
advisory.
they are saying, sir, ki, if there are the operational creditor and they are
Yes.
not giving the decision, they are not giving any vote. Still,
Madam,
they are
yes.
because
Madam,
they are
go
So
to para 10 now, ma'am.
at that time,
Para 10.
para 10.
Yeah. Para 10.
Yes, sir. The advice of the shall not be binding on the liquidator. Yes, sir. This is always.
Yes.
But
that is
But
as
it will
regard
be
to
a
onerous
problem, madam.
property.
This
That's
section
not for entire.
is
That
not
is only
helpful
for
actually.
onerous property.
For all cases, for everything.
This
No,
this
no, no.
This is
the
for everything.
Section
this is
10
the
is
Sir,
regulation 10 is only for onerous property.
that is read what it is a
No,
subsection.
it
It is
is
not
for
the main
No,
section.
no,
not
not
for
It is
everything.
subsection.
Sir,
Yes.
can I read the whole
Yeah, please.
regulation here?
That is in
Yes, sir.
respect of onerous property.
Yes, sir. Sir will
No, it
read
is
the
for all.
No,
Not
no.
sir, please, sir. I will read the whole regulation, no, sir. The voting shares of the members of the committee shall be in proportion to their admitted claim in the total admitted claim. Now, the provided a secure creditor who was not relinquish his security interest under section this shall not be the part of the consultation committee, provided that the promoters, directors, partners, or their representatives may attend the meeting of the consultation committee but shall not have any voting right, provided further that a financial creditor or his representative, if he is a related party of the CD, shall not have the right to vote. The liquidator may facilitate the stakeholder of such class, namely financial creditor. Sir, some voice is coming from the participants. Uh, uh, each class, namely financial creditors in a class, workmen, employee, government department, other operational creditors, stakeholders, partners, to nominate their representative for participation in the consultation committee. If the stakeholder of any class fail to nominate their representative under this regulation, such representative shall be selected by the majority of voting of the class represent and voting. The representative under this regulation 3 and 4 shall vote in proportion to the voting shares of the stakeholders it represents. Now, subject to provision of the code and these regulations, representatives in the consultation committee shall have access to all relevant records and information as may be required to provide advice to the liquidator under sub-regulation 1. The liquidator shall convene the first meeting of the consultation committee within 7 days of the liquidation commencement date and may convene other meeting if he consider necessary on the request received from one or more member of the consultation committee, provided that when a request is received by the liquidator from members individually or collectively having at least 30%, 33% of the total voting rights, the liquidator shall mandatorily convene the meeting, provided further that the liquidator shall convene subsequent meeting within 30 days of the previous meeting unless the consultation committee has extended the period between such meetings, provided further that there shall be at least one meeting in each quarter. In all cases where the liquidator proposed to continue to initiate any legal proceeding, he shall, after presenting the economic rationale for the proposal, seek the advice of the consultation committee. In every meeting, the liquidator shall present to the consultation committee the actual liquidation cost along with the reason for exceeding the estimated cost, if any, the consolidated status of legal proceeding and progress made in the process. The liquidator shall chair the meeting of consultation committee and record the deliberations of the meeting. The liquidator shall place the recommendation of the committee of creditors made under sub-regulation 1 of this regulation before the consultation committee for its information. The consultation committee shall advise the liquidator by vote of not less than 66% of the representative of the consultation committee. So only advice. Here it is not bounding on the liquidator कि they should accept the decision. Explanation is here. For the purpose of this sub-regulation, the terms voting shall mean voting cast by representative of the consultation committee. The advice of the consultation committee shall not be binding on the liquidator. So for all the matters, the whatever is mentioned above, the liquidation is not, the liquidator is not binding. The advice they can provide, but the liquidator shall not be binding. Provided that where the liquidator takes a decision different from the advice taken by the consultation committee, he shall record the reason for the same in writing and submit the records relating to such decision to the adjudicating authority. So
Yes.
if they have take any decision which is not as per the advice, so they will submit the report to the adjudicating authority only and to the board within 5 days of said decision and include it in the next progress report. So
So
this is
the
only
issue, madam. It is
Yeah.
not easy that you report and the matter is finished.
Okay,
Litigation
so
will prolong.
And
Yes.
it takes time for the NCLT. They could ask so many questions on this. It is not simple that it is not binding.
So, sir, what is the
And the
solution?
stakeholders are the main stakeholders. How a liquidator can decision will be, it will be questioned
Yes.
by the
So,
NCLT even.
so
It is
what
only
is it?
intimation. It is
So,
only intimation.
Rather
It is
than
not IR.
there are instances of complaint to IBBI in these matters.
Yes, yes.
so, sir, please suggest what is the amendment is exactly required in this regulation.
I have suggested in the chat box that
Yeah.
whosoever comes and vote, the one who abstained, his percent voting should not be calculated for the purpose of calculating this 66%. That is the only
Sir,
way.
this is
The
your in
stakeholder who
case.
is my
Sir.
suggestion is that the stakeholder who is going to take anything from the under section 53,
Yeah,
most
yeah.
of those stakeholders should be there only.
Yes.
Rest are only advisory.
Ah.
They may come to, but no voting without voting rights.
No, they hijack the decision.
Yeah, definitely.
Because in my case, 1/3 of the voting right is with the government department. There's
Okay.
custom tax, and there are a lot of governments. They don't
Okay.
take any decision, and no agenda is passed.
And
Be calculated from the body. Sir, this
they
is
only
your
disturb the liquidation process.
sir, I think Harvinder Kumar sir is
Yeah,
saying
yeah, yeah.
something na.
Yeah.
This is your comment na, sir.
Yeah,
In
yes,
case
yes.
of decision in the SCC, the percentage should be calculated from the member who participated and voted, and voting share of those abstained should be excluded. This I don't the 53 the waterfall mechanism someone has suggested that the person the creditors
The person stakeholder who is going to take anything from the liquidation estate under section 53, only those stakeholders should be given voting rights.
Sir, lekin
It is very
53
difficult to
sir,
decide 53.
yes,
Why
yes.
not? Why not? Once you have liquidation,
No, sir, there are
No,
PUFE claims which are more
yes.
than this. They said we may be getting
PUFE
there.
is altogether different. It
Sir,
is
sir,
That is
in
also asset realizable,
sir,
na?
sir,
Yes.
in 53, the state government or other governments are also considered as a operational creditor. So
Yes.
they are also the part of the section 53. So how can we take they?
May I?
Yes, sir. Yes, sir.
Ma'am, when any of the act, not only this, even from the constitution, all acts, when there is a provision for simple present and voting, these are for very, very small matters. When they say by the majority of the vote, for more serious, but when they say 66%, that means the matter is serious. That is why they have put it 66%. See the scheme, it is not that what we
By
want.
vote not less than 66%
When
of
say
the
66,
representative
not
of
less
the
than 66, that means matter is really serious, and they want that should be almost consensus. See the scheme of the act.
Sir.
It is a serious matter. We cannot dilute it that okay, present and voting. That means somebody is holding the more than 51%, and out of 49% stakeholder, they come with the 3-4%. They say okay, it is passed. Quorum is complete and it is passed. You cannot hijack the like this.
Sir, but in the CIRP there is also mentioned na present and voting.
Yes. On what
Yeah.
matters? On what matters? On what? See the matters. On for what purpose it is present and voting. See
Sir,
the See, no, ma'am. In CIRP also 66%, 90%. What do you say that all are by present and voting? In CIRP, what decisions are all decisions by present and voting?
Yes, sir. Present and voting. So yes, sir. Some of the
some
sir,
are there, some are there, not all. But can you allow the withdrawal with the present and voting? Can you allow the that
No.
you use
90% is required. Yes.
then
So-
there's some
But
so
we-
that the purpose is 66% when it is there. Yes, you
but
can say.
but they
Yeah.
can, because at that time, sir, all operational creditor was also the part of the committee, the SCC. The government authorities are also the part of the SCC. So,
Yes, because they are
it
a
is-
stakeholder. They are a stakeholder. In one case they say, okay, government dues will have the first priority.
But
I
sir,
forgot the name of
sir,
the case
sir,
before I was reading.
Sir,
Yes, please.
first operational creditor having the priority from the financial creditor in all cases, sir. This is there are so many cases in which said, and as per the waterfall mechanism, it is also described. But here there are some of the difficulty was facing due to the representative are not coming in the meeting and they are not voting. So in this situation, there should be some clause for the security of the
The
liquidator
process
also.
should go on, no? It should
Yeah.
not be stalled.
Yes. So in this case, you can go to the adjudicating authorities. That okay, they are not coming.
The voting
That is the
percentage
only
may
way. We cannot dilute the
by
voting
majority,
percentage.
51% say. Instead of 66%,
Sir,
51%
if
may
we
be
have to
mentioned.
go for auction and we are not able to fix the reserve price in the absence of the 66%.
Agree. In that case,
So
there is
you know how
there
the NCLT is functioning,
I
how much
know,
time.
sir. I know, sir. But we cannot dilute certain provision which is so important.
So that
But
means
that's- that-
it will not be finished in 360 days,
Sir,
which
there
is
are
the.
there are lots of things which are not being finished in 3 years.
But wherever there are stumbling blocks, we need to look at it.
I understand that, sir. That I understand.
But
There is an adjudicating
sir,
authority. Now we can go to that. We can go for the
And it is
instructions.
just a
That we-
suggestion. Let
Yes,
the
I
IDBI
agree.
put their mind. And
I am also suggesting. I am also suggesting. I am not saying. I am not saying that this is the final.
Percentage
I am
may
also
be
suggesting.
lower. Instead of 66%, it may be 51%.
Sir, because in CIRP the voting power is 66%. So here is the same, sir. Na? So how can we suggest
But
now
if no
you
decision
can
is
take?
taking place, then there is no use of set percentage, 66%.
I think we should make a suggestion. Let them look at.
Yes, sir.
Madam,
Please mention your suggestions
before
in
this
the
30
chat box. Yes.
before 31A, whatever regulation was there, it was not for including operational caterer. That regulation, as per that regulation, only the financial caterer, secured financial caterers will be a part of that.
Yes,
they have been voting,
and
right?
security. Yeah, so this is very good point, sir. Because the only if fee was payable only through the COC, the financial creditor have required to pay the fee of the liquidator if this is not realized from the value of the assets. So the voting right should also be given to them only.
Yes. Because liquidation cost is to be by only secured financial caterer, not by the others.
But earlier, ma'am,
Or the government department will not contribute a single rupee.
Yes.
But earlier, ma'am, we have suggested the fee should be paid by the financial or operational creditor.
No, sir. We have written here the committee of creditors. The fee should be paid by the committee of creditors.
Okay.
Voting right should be given only to the committee of creditors.
No, yes. Secured financial creditor.
Yes. Means financial creditor, secured or whether not secured.
Yeah,
doesn't
financial
matter.
creditor.
Yeah.
Okay. Ma'am, SCC given to the secured
Means,
financial creditor. Financial creditor,
the
yes. To the financial creditor.
So, sir, can I conclude now or any other suggestions?
Yes, ma'am. If
Ma'am,
Yes.
there is no term of financial creditor during liquidation. It is secured or unsecured.
Yes, that is
So
true.
you may write secured over there.
ma'am, it should be a committee of creditors because earlier we had discussed there may be possibility there may be no financial creditor. Supposing operation creditor.
Yes, so
Yes.
the financial creditor, or if there is no financial creditor,
Or in their absence,
or in the absence of
financial creditors, the operational creditor holding more than 5% say.
then only operational creditor.
Then top 18, madam, as it is there in CIRP.
Yes, sir. So, can I conclude now, sir? Or any other
Yes,
consultation?
yes.
Yes, ma'am.
Is it 31 or 31A?
31A.
This is
31A.
31 subsection 4.
31. Yes.
31 subsection 4.
No, 31 is
on
not.
No.
31, sir, I'm showing you.
31.
31A. 31A.
31A is about voting percentage.
Stakeholders.
31 means
The
list of
consultation committee.
stakeholders.
Yes.
Madam, see 3A, para 3.
Para 3 of
3A.
this
3A.
3A, sir, is not here. 3 and 4, 4A is here.
No, 3A, no, at the top.
Okay.
At the top.
3A.
Para 3.
Three eligibility.
2A.
3A, para 3.
A is here. Is eligible.
No.
It is 2A, not 3A.
Sir, there is no 3A, sir.
It is
2A,
2A.
2A.
Yes, you're right. 2A, 2A.
2A.
2A, I think it is.
2A, yes.
Okay, 2A. Yes, sir.
Para 3.
Contribution to the liquidation
Yes.
cost.
Yes.
Please come to para 3.
Yes, sir. Para 3.
Repayable with bank rate.
Yeah.
Hmm.
Whosoever paid, they will be repaid.
Huh?
The amount contributed under sub-regulation 2 shall be repayable with interest. Amount whatever is contributed, I think they are.
Initially,
Yes.
it will be contributed by the financial
Yes.
creditors.
Yes.
Later on, it will
Later
has
on,
to be refunded to financial creditors
financial
out of,
with the
from
interest.
liquidation cost.
Even the liquidator fee also, that will also be
Not
repaid. Yes.
No, not liquidator fee.
Sir, this
Why
is the
not?
It
only
is to be
contribution.
paid from
Sir.
the realization of a liquidation
Sir,
estate.
only
Yes,
the
we-
difference between liquidation cost and liquid surplus, liquid asset.
Yes,
Liquid
because
asset
they
is
have
cost
mentioned
cash
here.
only.
They
If the
have
balance sheet
mentioned here.
is,
The
if the
excess
balance sheet is
contribute.
having some cash or
Oh.
fixed deposit, whatever the liquidation cost minus these kind of assets
So
to
liquidation
be
cost,
contributed.
liquidation cost includes liquidation fee. Liquidator's
That
fee.
liquidation cost as estimated under regulation 39B of CIRP.
No, liquidation cost includes liquidator's fee.
Yes, perfect.
Huh.
18.
Maybe.
Yes.
Maybe.
It's not only the initial contribution. It's the entire contribution.
No, initial contribution. It
No,
has to
sir.
be refunded from liquidation cost.
No, sir. Entire
With
contribution.
interest, it has to be refunded.
That's the entire contribution. Not only the initial contribution. Initial
To the
contribution.
financial creditors.
So,
To the financial creditors. Financial
sir,
creditors
this is only
initially.
the
Towards-
contribution amount, sir.
Towards liquidation.
Hmm.
It is towards liquidation.
So,
Towards liquidation cost.
Yeah.
Falling
So
short of.
That includes the entire liquidation fee, entire cost.
Yeah.
Yeah.
See, something
How
is
they-
met from liquidation, liquid assets, and the remaining is to be contributed by the financial creditors. And that whatever contributed is to be refunded from liquidation cost later with interest of bank rate.
Sir, because 6 is already, the time is already going on. So we'll conclude with this discussion. So thank you to all the participants for taking part in the discussion and your suggestions and your all feedbacks. So now I'm requesting to the ICSI IPA for the conclusion of this all webinar series, because today is the last day of this series. And since June, we are taking the part in this sessions, and I'm very thankful to all the participants.
Thank you, ma'am. Thank you very much.
Thank you so
Thank you,
much,
madam.
sir.
Thank you
you,
very
sir.
much.
Thank
you, madam. Thank you very much.
thank you so much.
Thank you. Thank you, ma'am.
Thank you, ma'am. Good to leave now.
Yes, sir. Yes, you may leave, sir. Mama.